The third case on the docket for Wednesday, March 30th, 2022 is appeal number 124619 in the matter of R. Jacob Johnson, original action and attorney discipline, no briefs filed. Your Honor, that concludes the docket for the week of March 28th.
Counsel, would you please approach the lectern and enter your appearances?
Good morning, Madam Chief Justice. May it please the court. Julia Hart, Deputy Disciplinary Administrator, appears on behalf of the Office of the Disciplinary Administrator. I request permission to reserve 3 minutes for argument or for rebuttal argument.
3 minutes is granted.
Thank you. I am present and ready for argument.
May it please the court, the respondent appears in person by John Ambrosio. We are certainly ready to proceed.
Settled, you may begin your argument.
Thank you. May it please the court. This is an attorney discipline case where the parties jointly submitted a summary submission agreement pursuant to Supreme Court Rule 223. Pursuant to this rule, the parties are in agreement that the respondent violated the Kansas Rule of Professional Conduct 8.4b. The parties agree through this submission to the findings of fact and the conclusions of law, and the parties recommend that the respondent be publicly censured as a result of this violation of the rules. The respondent is licensed to practice law in Colorado, Kansas, and Missouri. In Kansas and Missouri, the respondent's licensure status is inactive. In Colorado, he has an active law license. This is a reciprocal discipline case pursuant to Kansas Supreme Court Rule 221. The events that led up to this summary submission were in November of 2019. The respondent was convicted of misdemeanor assault in Colorado. He reported this conviction to all states that he is licensed. The respondent has had no prior discipline on his license in any of the states of which he holds a law license. In Colorado, where he has an active license, the respondent entered into a joint stipulation with the Colorado Office of Attorney Regulation. In this joint stipulation, the parties recommended and the Supreme Court imposed the following discipline in June of 2020. The court in Colorado imposed a 1-year suspension with all but 5 months of that stayed, so long as the respondent completes a 24-month probation with various terms and conditions. This probation is set to expire in January of 2023, and he remains on it. The terms and conditions of this probation are set forth in the record on page 49 of volume 1. The respondent is in compliance with all terms of his probation through the Colorado Attorney Regulation Office. Following along with the reciprocal discipline in April of 2021, the Missouri Supreme Court issued a written admonition to the respondent based on this Colorado conviction and subsequent discipline. Both Colorado and Missouri found that the respondent was in violation of the Rule of Professional Conduct of 8.4b. This is the same rule of which the Board of Discipline agreed and found the respondent was in violation of here in Kansas. All 3 states based their rules of professional conduct off of the model rules of professional conduct, and 8.4b is identical in all 3 states of which he was found in violation. Because the respondent has successfully completed the terms and conditions of his misdemeanor probation and has complied with all terms and conditions of his Colorado attorney regulation suspension and subsequent probation, I join in with Mr. Ambrosio and the respondent in asking the court to impose a public censure or a published censure in this case. Thank you.
I have one question, and
Yeah.
this may be fairly obvious. This is part of, I think, all of our adjustments to the new process and the formatting of the submission. And you have in that submission placed one category that says applicable aggravating and mitigating circumstances, and then listed them without differentiating which you consider aggravating and which you consider mitigating. And as I said, this seems fairly obvious. It seems to me like the first two regarding that in essence, there may not be any aggravating circumstance. The one I wasn't sure how it was categorized was the first one, which was an attorney since 2007. It seems that everything else is likely to be intended to be a mitigating circumstance, but I'm not sure where that one fell, on which side of the line.
I appreciate that. And you are talking on page 52 of volume 1 of the record. Paragraph 26, respondent has been licensed as an attorney since 2007. I would consider that to be an aggravating factor more so than a mitigating factor, in so much that he has experience, he understands the rules of professional conduct, and this violation still occurred. As the court is aware, this is a new rule and we continue to have discussions and evolve, and I believe it will be our practice in the future that they will be separated out more clearly.
And then am I correct that everything that follows from there, paragraphs 27 through 32, were really intended to be mitigating circumstances?
Yes, ma'am. Thank you very much.
Mr. Ambrosio?
Madam Chief Justice, your honors may please the court. I love the new rule 223, and it's probably because I'm a slacker and the less work I have to do, the better I like it. And my colleague is absolutely right. I agree with everything that she indicated during the course of her argument. She's right on target. And I agree that from now on, and I should have noticed that, it wasn't her fault. I should have divided the aggravating and mitigating pieces up so it's easier for you to review. My client does not in any way excuse his behavior on that bad night a number of years ago. He stands up to the plate and admits he was wrong. And I think we described in our submission what was going on with him. And I'm not making an excuse. Any type of violence, especially domestic violence, has no basis in any civil society. But during the time he was going through this, and again, it's not an excuse, he had a new baby that was in the house, that was in and out of the hospital on a constant basis. I think he told me he had just held his child 3 or 4 times before this bad day that this all happened. And then there's pressure. He and his wife aren't sleeping. I'm sure they're at each other, as all couples are, especially after you have a child. I'm sure it was difficult. And then you add alcohol to that stress, and we have what happened. He was inappropriate. He put his hands on the person he loves, and there's no excuse for that. He was wrong. Maybe they could have worked it out back then. She chose to call the cops, and I don't in any way falter for that. I think any woman who doesn't call the cops, or any spouse who doesn't call the cops when they're abused, makes a mistake. This couple has put this marriage back together again. The child is in good shape. The child is healthy. They're doing great. They're building a house, have built a house just outside of Wichita. He's back practicing law with the same firm in Colorado that he was practicing at the time. Everything is going great for him. I urge you to follow the recommendations of my friend and colleague in the Discipline Administrator's Office and myself, and do a censure and make it published, because that's our agreement, and a deal's a deal. Nothing less, nothing more. He's learned his lesson. You won't see this again. He's been back practicing law since a year ago. I believe his suspension, not a suspension, but his probation will be up in another 5 or 6 months, will expire 1/1 of 23, I believe. He's doing a good job. He's bright. He's inquisitive. He's back with the same law firm. Give him a chance to continue to practice. That's all I have to say. With your permission, he would like to address the members of the court.
Counsel, I did have one question, and whether you or your client respondent wants to address it. It sounded like as part of the terms of probation, there was educational coursework or some classwork that he undertook, and I'd just like to learn more about that in terms of whether it was anger management or.
I think if, with the court's permission, he'll answer that.
Thank you.
Answer that. And by the way, I also filed the affidavit because the new rule indicates you have to file an affidavit. I wasn't sure in this case if it should be filed, but I thought as an exercise of being rational and reasonable, I filed it anyway. So I apologize for that. May he address you?
Senators, thank you for giving me the opportunity to address you. I haven't practiced law in Kansas since 2010, but I
Sir, can I
know,
interrupt you? Because I'm not sure the mic's picking you up.
sorry,
They always can hear me.
sure. So be that as it may, I know that I have a continuing obligation to adhere to the ethical standards and maintain the integrity of the law. And I clearly failed by my actions back in 2019. And so for that, I truly apologize. Your Honor, to answer your question, so I did have a deferred judgment in Colorado, which required me to go through essentially a set program that they have for domestic violence, family violence. I think it was 45 weeks of not necessarily anger management, but couples management. It helps you understand some of the characteristics of your relationships, your communications, and how to be better, and how to not, I want to say, not be threatening to your spouse. You know, just little things that you may not realize. Like, for example, if you're in an argument with your spouse, pay attention. Don't stand between them and the door, for example. Like, let them know that they're free to leave. So just kind of things like that help you with your communication with your spouse. And so for me, I think it's not a set program. It can be up to something like 48 weeks. I think for me, it was 44, something like that. But I did complete that program. Is that a sufficient answer?
Yes,
Okay.
thank you.
So with that said, my wife and I, as Mr. Ambrosio said, we're in a much better space today than we were 2.5 years ago. It was a tremendously stressful part of our life. And I do not say that to condone my actions. Obviously, I was in the wrong, but my son was in and out of the hospital the whole week leading up to this happening. And on the night in question, I had exhausted my abilities to handle appropriately my emotions. And my wife and I got in an argument, and I put my hands on her, and I never should have done that. I've gone through a lot, both as a couple. I certainly have gone through a lot individually to address some of those characteristics of our relationship that were not good. And we've come a long way, and we're much stronger today as a couple, as spouses, and as parents than we were 2.5 years ago.
Thank you. Ms. Hart, you reserve 3 minutes.
Thank you, Chief Justice. I don't believe that there is anything that I need to rebut with that argument. Thank you.
Thank you. Thank you to both of you for your arguments today, or all 3 of you for your comments today. The court will take this matter under advisement